Yes, Mr. Crawford, it's on to grounds, I think.
Not quite. I thought it was best to begin with Lord Justice Mail's puzzlement factor. And so, my lord, my ladies, really 5 points. First, we do not know why Betta brought the claim that it did in the form that it did. Second, to the extent that Betta feels able to do so, and such matters are not privileged, Mr. Reed will explain Betta's position. Third, all I can do is speak to Tomini's position. It is admitting the debt, but not admitting the claim for a declaration. Fourth, Tomini has decided to take that position at board level. The material relevant to that decision isn't before this court, and at least partly is covered by privilege. But below, as here, there is Mr. Salome's evidence. Mr. Salome is a director of Tomini. Mr. Tomini explains in his witness statement why Tomini is doing what it's doing, in short, because it believes the debt to be due, and it believes the evidence in favour of the debt to be overwhelming. It believes the commercial imperative to admit the debt to be clear. See in particular paragraphs 17, 30, 17, 30.1 and 35 of his witness statement, which are all in supplemental bundle 271, 276 and 279. So he explained Tomini's position. Of course, all Tomini can do when it's faced with a claim is play what's in front of it. And then the fifth and final point is really to urge this court to guard against what I'd call as a shorthand the Sherlock Holmes fallacy, which is if there isn't a good explanation for why the claim's being brought in this way, it must be an abuse. Or it strengthens the case of abuse. The judge held, having read Mr. Salome's evidence, having considered all the material before him, that the case of abuse was weak, and then made the evaluative judgments that he did. And so, as tempting as it might be to adopt a Holmesian approach, in my submission, it would be wrong to do so on the material before this court and on the appeal before this court. If I might then turn to ground one, it's important to anchor this appeal in the grounds, as I've said. So they are at core 16.
I've just realised, obviously, that I've gone and left the core bundle in my room. Could you call my clerk?
Yeah, of course.
Julie phone.
My lord, whilst we just wait for that, just on timings, my lady has just indicated that the court has to rise at 2:45. Is that right?
We can squeeze 10 to.
10 to. I will take with both hands.
I have to be online, papers organised in my room for 4.
Of course.
So
no,
I can run, but I still have to get online
I'm
and
certainly
find
not going
the
to.
papers.
I'm very grateful for the indication, but I'm certainly not going to be the one who makes sure they should run. And Mr. Reed has indicated he might be less time than he was.
I don't want to put pressure on you.
No.
And I mean, at the end of the day, if I'm a little late, I'm a little late. So I'm not going to certainly not going to put pressure on you.
I'm grateful, my lady. My lord will just may I continue?
Carry on, because I have it in mind.
So paragraph 4, ground 1. The judgment was wrong within the meaning of PD 52C, paragraph 5(1)(a), because the judge failed to apply the correct test under CPR 3.12M and or 19.22. So the challenge is only that the 3.12M challenge has been abandoned, rightly so. That there's authority saying that it's not going to be satisfied where 19.2 is relied on and isn't satisfied. So the challenge is only to the correctness of the test under 19.2, not the correctness of the test for intervention. That would be hopeless, because the test for intervention is interest of justice, and the judge identified that and then it explicitly applied that. Just for your note, the references are paragraphs 36 to 37 of the judgment at 61 of the core bundle, where the judge identified the interest of justice test, and then that is the test that he explicitly applied at 56 of his judgment, core 67. His conclusion that it was not in the interest of justice to permit Mr Vatistas to intervene was, for reasons I'll seek to show in due course, unimpeachable, but that's really the subject of ground 2. Just for your note, given that there's no live challenge to the test applied on intervention, I would remind the court of paragraphs 34 to 39 of our skeleton at core 173, really just for rereading or emphasis when time allows. The challenge to the test under 19.2 is no more promising, and the test is set out at paragraph 38 of the judgment at core 62. If you might turn to that. And then, as Mr Vatistas fairly observed at paragraph 40 on the same page, the judge correctly identified the principles derived from Pablo Star governing the application of that test, so a wide construction of in dispute and the 2 lodestars. And then the judge at 57, paragraph 57 that is, my ladies, my lord, at page 67, it explicitly applied the 19.2 test and the Pablo Star principles. And you see that in 57, he addresses both limb A and limb B of the 19.2 test and says that neither is satisfied. That's his evaluative judgment, and it's an evaluative judgment based, of course, on all the circumstances, but in particular, the reasons given at paragraphs 52 to 57 in particular, although one also needs to read some earlier paragraphs of the judgment as well to contextualise those paragraphs. So he identified the correct test and he applied the correct test, and there's nothing in ground 1 as a result. Ground 2 is where the meat of the appeal at least appears to be, because ground 2, if you go back to core 16, asserts that, again, just confined to the joinder test, the judge misapplied those tests by failing to take account. Note those words. So that's the primary position is failed to take account. That would, if there were relevant factors, that would potentially be sprint room wrong. But as I'll show you, it isn't right. The judge took into account all 4 matters. And so ground 2 on analysis, on a proper and fair characterisation of the judgment, is a complaint only about weight. And the submissions I've already made in relation to that apply. It's a very difficult challenge to bring, to say an evaluative judgment is unsound because of weight. If I can deal with the factors in turn, this dovetails with some of my responses to Lord Justice Mayer's earlier on common ultimate control. And if I might take you to our skeleton as the most convenient place to show you this, at 177, core 177. Paragraph 48, my lady.
Thank you.
And then if I might just invite you to read that and then on to 49, but you'll see the paragraphs of the judgment, which are 3 and 4, in which common control are referred to. Common control is as we say front and centre in the judgment, front and centre in everything Mr Vatistas said below. But then importantly, 49, it is far from indisputable that Mr Diab has exercised control over Tomini's board, because ultimate control and practical control are obviously different things. and the point is made there that the only example Mr Vatistas put forward in support of his assertion of practical control was the discontinuance of the arbitration, but there were cogent reasons for the discontinuation of the arbitration. So that there's no evidence of practical control by Mr Diab of Tomini. And that's the basis on which the judge was obviously entitled to approach the questions before him. Then the risk of the fraud on the English court, I said that was expressly taken into account. If I might show you first Core 62, paragraph 41 at the bottom of the page. This also was front and centre in the application. It was really the entire basis of the application was that there will be an abuse unless I'm joined or permitted to intervene. And then the other paragraph, which makes express consideration clear beyond argument, is 52 at page 66 of Core. Just lost a button. We'll return to 52 in the context of ground 3. Just note these three arguments that are identified by the judge. So 3 steps in the abuse argument. It's completely consistent with our respondents' notice and with how my Lord Justice Mayles understood the case below and indeed the case before this court. There are 3 steps. There is no debt, 1. And it's abusive because of that and because of the claimant's motivation and because the defendant's directors are acting in fraudulent breach, knowing breach of their fiduciary duty. That's the position that Mr Vatistas urged. And then, as you'll see, in due course in relation to ground 3, the judge goes on to reject each of those 3 arguments. And so that's sub 2 of ground 2, obviously explicitly taken into consideration. We're just on weight. Sub 3 is what is ambitiously characterised by my learned friends as Mr Vatistas's unrebutted evidence of the position in Romania as a matter of Romanian law. Of course, Mr Vatistas, not being a Romanian lawyer, is not capable of giving admissible evidence as to Romanian law. Not evidence at all. It was just assertion. So he said the English proceedings, a judgment in the English proceedings would be likely to have a significant effect in the valuation proceedings in Romania. That is properly characterised as pseudo-expert evidence that the judge would have been entitled to disregard entirely as inadmissible. But that is not what the judge did. He explicitly weighed Mr Vatistas' concern that an English judgment in these proceedings would tend to depress the value of Mr Vatistas' shares in the Romanian valuation proceedings. And he did that in paragraphs 6, 11 and 41 of the judgment.
It's not quite depressed the value, is it? I understood it to be common ground that Tomini can't pay a debt of $40 million.
Well, I mean, it might wipe out the value, but I mean, depress or wipe out.
Yeah. So the moment that the judgment to which you're prepared to submit is given against you, you'll have to file for insolvency, won't you?
Well, again, my lord, at the risk of annoying you, I urge care in what we take as read. Mr Vatistas' case was that it would enable Abbottswood to acquire his shares for a sum, and of course, it may be that the company would be insolvent once that debt were recognised. But I mean, there doesn't need to be an English judgment for that debt to be recognised. Mr Salome has already said that Tomini admits the debt, and then there's a, if Mr Vatistas is right that the directors are acting in breach of director's duty in admitting the claim, then Tomini would have a claim, a valuable asset that Tomini would be its claim against its directors for that breach of duty. So that the solvency is not a straightforward question, as in the ultimate solvency, the ultimate value of Mr Vatistas's shareholding is not a straightforward question. But in any event,
well, it seems to me that if it's amount which you can't pay, then they're either going to enforce the debt against you, in which case it's solvent.
yes.
Or they're not going to enforce the debt against you. In other words, they're going to forgive it, in which case you'll have to pay tax on it, just as Mr Vatistas would have done.
Yes, well, my lord, of course that's an orthodox analysis, at least through the prism of English insolvency law and English company law. There's no Romanian law evidence here. But the complaint that I'm addressing is that the judge failed to take into account Mr Vatistas' evidence as to the effect of an English judgment on Romanian valuation proceedings. If the debt is admitted by us, that's a reality. And no one is suggesting that an English judgment is needed before the debt is enforceable.
Takes us back to why bother to spend hundreds of thousands of pounds on all of this.
Which is us defending the claim as we're defending it and admitting what we think is appropriate to admit. And I'll let Mr Reid explain why Betta has taken the steps that it has. But the complaint is a failure to have regard to what was said about the impact on the Romanian valuation proceedings, and the judge took it into account at 3 points in his judgment. And in any event, it was not really evidence at all. It was certainly not admissible evidence. It was just assertion by a lay person. And then the final factor relied on under ground 2, so subground 4 of ground 2, was the finding of the arbitral tribunal as to the risk of an abuse of its process at an interlocutory stage. Again, that was explicitly taken into account by the judge at paragraphs 22 and 23 of his judgment. In their written submissions, but notably not in Mr Petropoulos' oral submissions, Mr Vatistas came close to saying that the interlocutory decision of the arbitral tribunal really mandated a conclusion that joinder or intervention was appropriate or desirable, to use the statutory wording. And that would be hopeless, because the finding of the tribunal was an interlocutory finding only. It was based on different material from the material that was before his lordship, and in particular, it did not include a correct summary of the position in relation to the criminal proceedings in Romania. So it's a different tribunal addressing a different question, i.e., is the process of the arbitral tribunal rather than this court being abused, and coming up with an interlocutory view based on the pleadings alone and the exhibits thereto, no evidence. And so, in all those circumstances, again, as with Mr Vatistas' bare assertion as to the position under Romanian law, the judge would have been perfectly entitled to just disregard the procedural order, give no weight at all to what the arbitral tribunal had decided, answering a different question by reference to different material. But instead, he did weigh it in the balance. He did have regard to it, as I've said, at paragraphs 22 and 23. So, my ladies, my lord, I say all those four factors were explicitly taken into account, so the complaint in ground 2 that they were not is bad. And as to weight, none of those factors weighs so compellingly, either individually or cumulatively, in favour of joinder, that this court can say the judge was sprint room wrong. A fortiori given the judge's finding that Mr Vatistas' case was weak. But the weakness finding weighs so heavily in the balance against joinder that it makes it very hard for another factor or factors to countervail to such an extent that any appellate court could say the decision not to join was sprint room wrong. And so, for those reasons, we invite you to dismiss the challenge on ground 2. All relevant factors were taken into account. The judge was actually quite generous in the approach he took to relevance and admissibility, and the complaint of weight is not one that can realistically be maintained. Which brings me to ground 3. Ground 3 was not pressed or developed by Mr Patroclus because he said, and I quote, "Not a lot turned on it." His short point was he said that the judgment below had it backwards, and that Mr Vatistas could have asked for strikeout only if and after he was joined. That misses a point I've already made, which is Mr Vatistas could have had the courage of his convictions and said, "Join me so I will strike out, so I can apply to strike out." And that's not what he was saying. He was saying, "Join me on a wait and see basis. And so I can run a shadow defence or a derivative defence." So that's the first point. And as we'll see, the judge, on a proper reading of his judgment, just noted that that was the case, that in distinction from the Welsh ministers in Pablo Star, Mr Vatistas was not seeking to be joined to do something, to take a proactive step and say, "Right, I'm going to strike out," but rather just to run a shadow defence. So I may not need to spend too much time on this defence, and not that I have too much on this ground, not that I have too much time left in any event, but it is important to deal with at least to an extent, because I understood it to be one of the bases on which Mr Vatistas suggests that the evaluative judgment of the judge can be opened up or set aside, because he, to use Mr Patroclus's words again, had it backwards. If we could go back to the grounds again, but this time clause 17, ground 3, it's paragraph 6. Further alternatively, the judgment was wrong because the judge erroneously determined that strikeout rather than interventional joinder would be the most appropriate remedy to cure the abusive process identified by Mr Vatistas. That ground would have some force if the judge had anywhere so ruled, but that is not what the judge held. He did not hold that strikeout was the most appropriate remedy to cure the abuse alleged in the present case. Again, the essential context for this ground is the judge's conclusion on the weakness of Mr Vatistas' case. Nor did the judge hold that joinder intervention would never be the appropriate response to abuse. That would obviously have been wrong if he had so held. On a proper analysis of the judge's reasoning, in my submission, ground 3 mischaracterises and conflates two of the factors that the judge took into account in making the evaluative judgment that he did in refusing joinder or intervention. And ground 3 pivots narrowly and exclusively on paragraph 55 of the judgment, which is at page 67 of the court bundle. Just in passing, I should note that it's stated to be the third of 3 reasons found in the judge's conclusion at paragraph 56 that the interest of justice would not be promoted by permitting Mr Vatistas to intervene in these proceedings. And very possibly the reason why paragraphs 53, 54 and 55 begin first, second, third, even though at least 2 of them encompass more than one factor, is because they are responsive to paragraph 52, which we've already seen, where the judge identifies the 3 steps of Mr Vatistas' argument. So he's recited those steps and then said each of these aspects of the argument are problematic, and then that's the context for what follows. And when we get to 55, and of course a close textual analysis of a judgment, especially an exemplary judgment, is never that satisfactory an exercise, but this is the sole basis for ground 3, which is why I'm spending some time on it. the judge begins, even if these proceedings were an abusive process, permitting Mr Vatistas to make submissions would not be the or even an appropriate remedy. That is unquestionably part of the judge's reasoning. The next sentence is an observation en passant, which is obviously correct, which is the natural remedy where proceedings are an abusive process is to strike them out. That's just true. And then, but that is not the relief sought or what Mr Vatistas hopes to achieve. That is also true on Mr Vatistas' evidence and of very great significance. What the judge is saying is, Mr Vatistas isn't saying, join me so I can strike out, or even at some point I want to mount a strike out. He's saying, join me so I can run a shadow defence. So that's a perfectly fair observation on the evidence. And then the second factor comes in. I said this paragraph, it encompasses more than one factor. Mr Vatistas' objective is to transform these proceedings into a trial of the decisions made by the defendant's board of directors as to the conduct of the proceedings. This is not the appropriate forum for such disputes. The appropriate forum for the resolution of these disputes would be the Court of Romania or the valuation dispute. And that tracks back to the third aspect of Mr Vatistas' argument as summarised in 52. Mr Vatistas is saying Tomini's directors are acting in breach of duty in how they're defending the claim. And it comes back to a point we discussed before the short adjournment. Defendants, especially corporate defendants, are just allowed to run the defences that they want to run. And if there's a complaint against a corporate defendant's directors for the defence that they cause their company to run, then there are remedies available to shareholders. And the proceedings by which they would seek those remedies are the appropriate forum for such dispute to be ventilated. So nowhere in 55 is the judge doing what Mr Vatistas in ground 3 suggests he's doing. He's saying he's not seeking strikeout, he's not saying he would mount strikeout, and his real complaint is about the conduct of Tomini's directors. And that must all be read in the context of both 52, which I've already shown you, but also 57, which supplements and again contextualizes the reasons for refusing intervention. It's important to note that those first, second, third reasons are all on intervention, and then at 57 the judge says for those same reasons also evaluated judgment not to join, and then he repeats in explaining why neither limb A nor limb B of 19.2 is satisfied, and that Mr Vatistas' complaint is that the defendant is running the wrong defence. That is an internal corporate dispute between him and the defendant. These are not the appropriate procedures in which to resolve the internal corporate dispute. So that is echoes and reinforces the second factor in paragraph 55, and the first factor is he's not seeking strikeout. That's not what he's hoping to achieve by these proceedings.
Judge says at 57, the court can resolve all the matters in issue in the proceedings without the involvement of Mr Vatistas.
Yes.
Now, if that means can resolve all the issues on the pleadings, including your admission of the debt, no doubt that's right. But if that's given the more extended meaning, as in CPR 19, which is what he's addressing in this paragraph, how can that issue, namely whether there is a debt, be resolved without the intervention of Mr Vatistas?
Well, I can see that on just an analysis of whether the limb of 19.2 is satisfied, the essential precondition is satisfied, that could help Mr Vatistas, but he still has to get over the desirability question, which is the evaluated judgment. And this is, in my submission, not the most happily expressed paragraph, but the overarching conclusion in it is not desirable. The test for 19.2 read together isn't met.
But the first thing that the judge says in explaining his conclusion that it would not be desirable is that the court can resolve all the matters in issue.
But that it would be desirable, but that's supplementing, my lord, the reasons he's already given. So for the same reasons, I'm also of the view that he's not established on the evidence before me that it would be desirable that he be added as a party. And so then the next sentence has to be read in the context of that first sentence, which also incorporates, by reference, all the reasons before. So the reasons from 52 onwards. He's saying for all those reasons, not desirable. And then, to the extent that he's saying something that's inconsistent with Pablo Star, that need not trouble the court because it's just a question about the satisfaction of the precondition, and the value to judgment that it's not desirable is still sound. And my lord, it comes back to since something more than a barely arguable case is required, see Abraj, see Wise Payments, it can't be that if you just say abuse and scrape over the merits threshold, you thereby justify joinder. And that's really the shape of Mr Vatistas' appeal is, if you scrape over merits threshold and it's abuse, you get joinder, and that's wrong. The court always has regard to all the factors, in particular the strength of the case. It makes a multifactorial evaluative judgment. That's what the judge did. It's wrong to parse a judgment in a close textual way, particularly when it's extemporary after a day and a half long hearing. And even when you do analyse 57 in the close textual way in which my Lord Justice Mayles did, it's only right to have regard to all the factors and reasons that precede it. So for those reasons, in my submission, the challenge on ground 3 is a bad challenge. It's just not what the judge decided at all. The discussion that I've just been having, exchange I've just been having with my Lord Justice Mayles, does not actually figure anywhere in the appeal or in the grant. They're not saying it was wrong to hold that limb of 19.2 was not satisfied. Their attack is squarely on the evaluative judgment as to desirability. So it assumes in their favour that the conditions were met. That's the basis of ground 2. And ground 2 then says, but he failed to take into account factors that he should have taken into account. He failed to give them appropriate weight. That is the challenge that we have come to meet. And in my submission, now have no subject to any points that my ladies and my lord would wish to raise.
Did you want to say anything more about the issue that my lady brought up, namely mini trial?
Just on the mini trial, it was that we've really covered it in our skeleton argument. It isn't a mini trial. Both at Parby and Elite Property say a judge doesn't just have to take things at face value. A judge is entitled to look at material which contradicts or is inconsistent with assertions made by the person seeking to show that they have a real prospect of success. An evaluation is permissible, and in some cases absolutely the only right thing for a judge to do. What a judge shouldn't do is start weighing one witness's evidence against another. But that's not what this judge did. This judge said Mr Vatistas just has bare assertion, and it's contradicted by the weight of evidence, documentary evidence, and unsupported by any clear contemporaneous documentary evidence. That's not a mini trial. That's the type of assessment that the Supreme Court has said is appropriate. So it's not a fair criticism. And since it's not a fair criticism, my point that the findings in paragraph 53 are baked in stands. So I think bang on when I said I'll hand over to Ms Thompson with...
Just before Ms Thompson writes, anything else? Anything else? No, thank
so
you.
sorry,
No, we just wanted to check if we wanted to ask anything else.
In my enthusiasm to meet my timing estimate, I was very rude. I'm sorry.
Over to Ms Thompson. Thank you, Ms Thompson.
Thank you.
Respondent's notice.
Yes.
I just have to give her a mic.
Yes, please.
My ladies, my lord, Mr McCourt Fritz has already addressed and just discussed with you why the findings of paragraph 53 of the judgment are baked into this appeal. There's no challenge to them. And the respondent's notice is really about the logical and legal consequences of those findings. We submit that on the authorities, the findings of 53 lead inevitably to the conclusion that Mr Vatistas' case, that the debt was not owing and that the proceedings are abusive, has no real prospect of success. So if we turn quickly to the authorities, the test for whether a case has a real prospect of success is summarised clearly in the judgment of my Lady Justice Asplin in Elite Property. That's not in the authorities bundle because it's quoted and our skeleton in the core bundle at page 176.
Paragraph.
It's paragraph 42, it's the indented quote in the middle of the page. Reading 4 lines down, a claim does not have such a prospect where A, it is possible to say with confidence that the factual basis for the claim is fanciful because it is entirely without substance. B, the claimant does not have material to support at least a prima facie case that the allegations are correct. And then jumping down to the bold sentence at the end of the quote, the court is entitled to reject a version of the facts which is implausible, self-contradictory, or not supported by the contemporaneous documents. Now, the language the judge in this case used at paragraph 53 of the judgment, which was that Mr Vatistas' version of events was, quote, unsupported by any clear contemporaneous documentary evidence, is almost the exact language from Elite Property. We know the judge also found in para 53 that Mr Vatistas' case was inconsistent with and undermined by the weight of the contemporaneous documentary material. And such a case is a prime example of the sort of category of case which the authorities say does not have a real prospect of success. And if I can take my ladies and my lord to Parby, which I know we've already been to, but this is a different passage. It's page 232 of the authorities bundle. And at page 232, Lord Hamblin quotes the guidance of Lord Hope in 3 Rivers. If we look at line B on page 232, this is in Lord Hope's speech that's being quoted. Lord Hope is speaking of cases where it is possible to say with confidence before trial that the actual basis for the claim is fanciful because it is entirely without substance, and gives an example of where it may be clear beyond question that the statement of facts is contradicted by all the documents or other material on which it is based.
Sorry, I've lost you. I'm on page 232.
Oh, apologies, it's line B,
Thank you.
and halfway across we see the passage beginning in other cases it may
Thank
be
you.
possible. Thank you. We say when you put that passage and the passage in Elite Property side by side with what the judge found in 53, the logical consequence of the judge's findings must be that the case had no real prospect of success. It was a version of events which was unsupported by any clear contemporaneous documentary evidence and which was inconsistent with and undermined by the weight of the documentary evidence. And that meant it was mere assertion, as the judge found. And as Mr McCourt Fritz has already submitted, there are assertions and assertions. Not all mere assertions are created equally. But the mere assertion in this case about the debt not being owing has 4 really quite striking features. And I'll summarise them and then I'll go to them in a little more detail. The first is that it is an assertion made by someone who is on his own case dishonest and who has demonstrably misled the court in his evidence. The second is that it is an inherently implausible assertion. The third is that it is the sort of assertion where one would expect to see at least some supporting documents, but there are none. And fourth, it's an assertion by someone with a clear motive for making it. It's not the disinterested bystander to a road traffic accident. So turning to that first feature of the mere assertion, which is that it is made by a person who has demonstrably misled the court in his evidence. To give an example of that, the inescapable consequence of his own case was that he was dishonest with the Romanian revenue over a period of many years. He must have been a central party to that fraud on the revenue. But he's been far from candid with the court about that involvement in the alleged fraud. And to give an illustration of that, which Mr McCourt Fritz mentioned in passing, that's his evidence about the 2015 credit agreement, which is central to Betta's case. if we go to that document, it's in the supplemental bundle, and it's at page 54.
Page, sorry.
Sorry, page 54.
you.
So we can see that's an agreement between Betta and Tomini. We see from the first bullet point of the preamble, the borrower, that's Tomini, had towards Sovereign a debt in the amount of 194 million lei. We see from the second bullet point that Sovereign assigned its claim against Tomini to Abbottswood, which then assigned it to Betta. The claim of 194 million lei has been expressly recognised by Tomini, and the parties wish this claim to be formalised and guaranteed in accordance with the contract. And that's exactly what the contract goes on to do. So it's therefore a document which is entirely consistent with Tomini's case and Betta's case, and entirely inconsistent with Mr Vatistas' case. So his evidence about this document before the court below is in the same bundle at page 237, if we can go to that.
237.
237, paragraph 26 in the middle of the page.
The preamble that you showed us said parties wish this claim to be not only formalised, guaranteed, but also and recovered. But,
Yes.
Was that true? Nothing was done for years to try and recover it.
Well, if we just jump forward in that agreement, maybe if we go back to page 54, and the following page 55, we see that there are then agreed repayment tranches in clause 1, so the debt split into tranches. What then happens, and this is covered in the evidence of Mr Salame, is that the debt is not repaid and Mr Vatistas disputes the debt, and there's then an addendum known as the 2016 addendum to the credit agreement, which is entered into, which changes the repayment dates for those tranches. So if we move back to Mr Vatistas' evidence about this document, that's at page 237 of the supplemental bundle. Paragraph 26, he says in the first line, in the summer of 2015, without informing me, Mr Diab arranged for a company loan contract, that's the 2015 credit agreement, to be executed. He then describes the contents of that agreement. And if we jump four lines from the bottom of this paragraph, he says, in fact, all of this was false and known to be false by both Tomini and Betta, the sovereign debt having been finally and fully settled in 2009. So that's his explanation for this document. It's wholly false, and I wasn't informed about it being executed. That is just false. We know it is false because Mr Vatistas was copied to multiple emails attaching drafts of this agreement and discussing the mechanics for its execution. And we find those in the bundle at page 73 of this same bundle. So office at mavridin.ro is Tomini's lawyer, to gv@tomini.ro, that's Mr Vatistas. Dear all, please find attached, number 1, the credit contract for the amount of 194 million lei. And then the last 2 paragraphs on this page discuss the mechanics for execution. And there are then further emails attaching further drafts and discussing further logistics for execution of the documents, also copied to Mr Vatistas. Mr Salame exhibited these emails to his responsive evidence below. In reply, Mr Vatistas acknowledged these emails. He didn't dispute that he'd received them, but he gave no explanation whatsoever for why his evidence to the court that the 2015 credit agreement had been executed without informing him was wrong and misleading. We don't need to turn it up. The reference to that is paragraph 34 of his second witness statement, which is at page 303 of the supplemental bundle. There's another very brief example I can give of him being far from candid with the court about his involvement in what he alleges is a fraud. And that is his evidence about a document from Sovereign to Tomini notifying Tomini of the assignment of the debt. So I can just give you the references if that's all right. But in his first witness statement at page 236, which is paragraph 23, he says that Mr Diab arranged for that document to be fabricated.
I'm sorry, so that's page 236 of the.
Oh, I'm so sorry, supplemental bundle, paragraph 23.
That's. Yeah. Thank you.
Thank you. He says that Mr Diab arranged for the sham notice of assignment to be fabricated and backdated to the 31st of December 2013. What he wholly neglects to say in this witness statement is that at the time, he himself signed an acknowledgement of that notice of assignment. And the reference to that is also in the supplemental bundle. If I can just give it to you, it's page 44. There's no dispute that that's his signature that we see. 44. Mr McCourt Fritz gave you, so that was my first example of him being demonstrably misleading to the court in his evidence. Mr McCourt Fritz gave you two other examples, which I won't repeat, but just to remind you of them, they are one, leaving the court with the wholly false impression that the criminal complaint was still under investigation, when in fact the prosecutor had dismissed the complaint and then also dismissed his challenge to the dismissal. So it had been dismissed twice over. And the third example of being demonstrably misleading in his evidence was at paragraph 9 of our skeleton, page 163 of the core bundle. And that is the fact that he gave evidence to the court that all of Betta's claims were baseless. And then in his second witness statement, he admitted that actually, in respect of the claims, other than the claims for the 194 million lieu, in respect of the other two debt claims, he couldn't comment on the detail. So his assertion that the claims were baseless was in fact entirely without ground. Turning then to the second feature of the mere assertion, which is the implausibility of the assertion. As Mr McCourt Fritz mentioned, it is inherently implausible that Abbottswood agreed to pay almost $4 million for a highly distressed debt in circumstances at its face value, in circumstances where on Mr Vatistas' own evidence, Tomini was on the verge of bankruptcy. But his case actually layers implausibility upon implausibility. There's another example, which is his evidence about the 2016 credit agreement, which my lord, I mentioned in an answer to my lord just a moment ago. If we very quickly turn that up, that's at page 109 of the supplemental bundle. And we can see in the recital A, that refers to the 2015 credit agreement. There's also in recital T reference to an additional facility. And then if we go on, we can see, we don't need to go to it, but there are different repayment dates for each tranche of the debt that are agreed. So again, it's a document which is totally inconsistent with Mr Vatistas' case, contradicts his case. And so he does say, and he has to say, that it's a sham. But it's a document that he nevertheless signed on behalf of Tomini. His signature, for your note, is on page 116 in the supplemental bundle. That's the final page of the 2016 addendum. And the very date that the agreement was entered into, at a meeting of Tomini's shareholders, he also voted in favour of executing it. We don't need to turn it up, but that's page 102 of the supplemental bundle. Now, his explanation and his evidence for why he signed this document is that Abbottswood had refused to provide any other funding to Tomini unless he signed, and that while he objected strongly, he felt he had no other choice. That is an inherently incredible explanation. What is even more incredible, that he cannot point to a single document evidencing the supposed pressure that was placed on him by Abbottswood that was so overwhelming that he agreed to sign a document that he knew was a serious fraud on the tax authorities. It is also incredible that he cannot point to a single document evidencing the strong objections he says that he mounted. We say that his explanation for the 2016 credit agreement is a fanciful one. It is entirely without substance. So that was the second feature of the assertion, which was that it was an implausible one. My ladies and my lord will recall the statement in Elite Property we went to a moment ago, which is that the court does not have to accept implausible assertions when deciding whether there's a real prospect of success. I think I've got about 3 minutes left. So turning to the final two features of this mere assertion. The first is one that Mr McCourt-Fritz has already dealt with, which is the striking lack of documentary footprint. And that, of course, while one wouldn't expect formal documents evidencing the fraud, one would expect that over a fraud of many years there would be at least some internal communications. There are none. And the final feature of mere assertion is motive, which is that Mr Vatistas is not a disinterested party. He believes that a finding that the debt is not due will drive up the value of his shares. So where do we get to? The judge found that Mr Vatistas' evidence, or his version of events, was unsupported by any clear contemporaneous documents. Indeed, that the weight of the documents were inconsistent with and undermined his case. And those findings are baked in and they haven't been appealed. But what I do observe in passing is that having cantered through some of these documents, and it's only a small subset of what was before the judge and what the judge took into account, it's very clear that those findings are well within the wide margin afforded to the judge. Of course, there's no contention that the judge overlooked a specific document or that indeed he misconstrued or misunderstood any document. So that leaves us in the position that the case that the debt was not owing was mere assertion. It's not a mere assertion where the court can have any reasonable grounds for believing that that position might be altered in the course of disclosure. And to quote Elite Property, it was an implausible assertion, and it was an assertion made by someone who was demonstrably dishonest, and I took you to 3 examples of that, and who has a motive to lie. He's not a disinterested bystander. And in our submission, when you apply the tests as set out in Elite Property, as set out in Okpabi and Three Rivers, we see that when all of those factors are present, the inexorable result is that a case has no real prospect of success. And the judge should have gone on to take that final, and we say inescapable step in his reasoning, and that he erred in not so doing. So for those reasons, if you would otherwise be minded to allow the appeal on the grounds put forward by Mr Vatistas, we would invite you to dismiss the appeal on the grounds set out in the respondent's notice. And unless I can assist you further.
Thank you very much indeed, Ms. Thompson. Yes, Mr Reid.
My ladies, my lord. The first point to start with is an answer to my Lord Justice Mail's question earlier, which was, if I have a claim against you and you admit it, you don't go to court to get a declaration after you pay the money. And the answer I will submit is found in how this claim came about. If we could turn please to Supplemental Bundle tab 30, page 187. And the order that the arbitral tribunal made in the discontinuous is procedure order number 5, and it says this: unless the claimant 1 commences proceedings by the 13th of June 2023 against the respondent in the High Court of England and Wales, so pausing there, claim had to be issued. And then the second part, putting in issue the validity of the credit agreements and either including Mr Vatistas as a party or notifying Mr Vatistas on the same day of the commencement proceedings and confirming in such notice its consent to any application from Mr Vatistas to join the proceedings or to be admitted into the proceedings as an interested third party intervener permitted to make submissions to the court. So in unless terms, the tribunal said the only way we're going to give you the discontinuous without prejudice is if you comply with these terms. And one of those terms was specifically putting in issue the validity of the credit agreements. So I entirely agree with my lord that one would normally plead, what we see in the pleading, there is this contract, there is money owing, there is a debt, the order sought is please pay the money. And one can see in the particulars of claim, which is the
But
court.
that only, sorry to interrupt, but that only pushes the question one stage back. Because why did you arbitrate against them in the first place?
Well, my lord's, as I understood my lord's question, it may be that this is now a different question, but the question was, why is this pleaded in the way it is? I.e., why has Betta come to the English court asking for a declaration, which on its face seems odd? And I'm answering the question by saying, well, actually, Betta was forced into this position because of what the arbitral tribunal had ordered. So rather than simply saying, there is a contract and please therefore pay us the money, that wouldn't have put the credit agreements, the validity of the credit agreements in issue. So the only way, or the way that was done, was by saying a declaration that they are valid. And when one looks at the particulars of claim, the court will see that ultimately it is a for debt, albeit bolted on with declarations.
But I mean, still the question arises, well, if the debt is going to be admitted, why do you need an arbitration, which is far more expensive usually than court proceedings?
Yes.
You've got to pay the arbitrators for a start, and I think they put in quite a request, didn't they, for on the account?
Yes, is the answer to that. What I would say though is this, that the arbitration, or the reason why an arbitration was commenced in the first place, and or the reason why a party comes to court seeking a particular remedy, is not normally an inquiry the court would make. And so I'm not in a position to explain why Tomini has acted in the way that it has. All I can say is, in answer to my lord's question, the case was pleaded in this particular way because of the unless order that was made by the arbitral tribunal. And taking that one step further, if one looks at procedural order 6, which is supplementary bundle, tab 34, page 200. So Betta, having, we say, ticked the boxes required by the tribunal, sought to have the the arbitral proceedings discontinued without prejudice, and the tribunal said, no, we're not going to do that, and that's procedural order 6. What it did was stayed the arbitral proceedings until this application had been heard, determined, and then further, once that had been heard, Betta wrote to the tribunal saying, okay, now can we have our discontinuous without prejudice? And the answer is Procedure Order 7 at page 321 of the supplementary bundle. And the tribunal said, what we're going to do is continue the stay until the outcome of the appeal process. So the consequence of that is, as it stands, Betta is still on the hook for a discontinuance with prejudice, because all that's happened is that the arbitral proceedings have been stayed. So had we not ticked the boxes, as it were, then it would be that the course of action would would be that the cause of action could not be pursued because it would have been discontinued with prejudice. So all I can explain to the court is why it appears, perhaps on its face, strange, but the answer I would submit is because that's how the arbitral tribunal determined it to be.
Do we have the request for arbitration so we can see what you were asking for in the commission?
It's not in there. It's not in the appeal bundles.
Is it before the judge?
Yes.
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 This is an objection, it might be quite useful to see it.
I have no objections.
Yeah, perhaps we could be provided, I mean, not now if it's not to hand, but perhaps that could be sent to us.
Of course. So that's my point on why, on its face, it may look odd to the court. May I just take a minute? My second point is just the case management points that we had raised in front of the judge and asked some rhetorical questions, as my learned friend put it. Just because as claimant, trying to understand how is this actually going to work. And the judge dealt with it by saying these are points of relevance, but actually with careful case management they can be dealt with. Of course that's right, but when asked this morning as to whether this court should consider the case management elements, I understood my learned friend for Mr Vatistas to say, no, these are not points for the court to consider. I say this not opposing the appeal because that's not our position, but simply to try and assist the court. In the Lehman Brothers authority, which is the authority department in tab 9, starting at page 171, and the relevant part in paragraph 11, and my learned friend for Tomini dealt with it in a slightly different way. It says this: the more significant question comes under the discretion reported by, quote, may in the rule. It is for each of them to justify their joinder by showing that they can, or might with sufficient certainty, be able to bring something to the party without at the same time imposing any unnecessary, unfair or disproportionate burdens on the other parties or proceedings, the burdens on the applicants. Now I don't understand that to be a particularly controversial proposition, despite what my own friend said today. Now, that's
I
important.
understood what was said to be though. You, this court, are not concerned with practicalities. That will be dealt with elsewhere. That's as far as I understood what was being said, no more.
So yes, that may well be as far as it went. My point is this: that it's never been clear what Mr Vatistas really wants to do in terms of how he envisages this being. It appears from the submissions today that he effectively wants to be substituted for Tomini. And this came out in my own submissions when asked. When he sought to answer those practical questions, when he was saying, well, okay, well, the way we would deal with this is, will it be an alternative defence? Answer, yes. So the idea, it seems to be, that Mr Vatistas will run a defence de facto on behalf of Tomini. In answer to the question, okay, so what does that look like from, he said, the learned judge.
I don't think that's what was said either. It was expressly stated that this would be by Mr Vatistas for Mr Vatistas in his own name.
He did, I agree, he did say that, but he also said, my understanding is, I'll find it necessary, but he also then said, when making the submission about what does that state of the case look like, is it a substitute? The answer is yes. But I won't labour this point. I can see where it's going. The final point is one of security. It's a point that we raised in front of the judge. It was in our skeleton argument because it's something that we do have concerns about. Mr Vatistas is not within this jurisdiction, and so we pose the question: well, how does that work? Because he's joined as a defendant, as my lord says. we wouldn't ordinarily be able to make that type of application. And so I appreciate no submissions have yet been made on the point, but we did raise it in front of the judge, albeit it didn't go anywhere because the application was ultimately dismissed. And so I would ask this court to consider that point at this stage. So at least we've got an opportunity to pursue that if the appeal is granted.
My name is Manuel. Just one point arising from Manuel and Justice Nail's request for arbitration, if I might. Just really for your notes, just to remind you of the history of the arbitration as set out in our skeleton at core 166, paragraph 15 and following. In particular, Mr Vatistas' role in defending on behalf of Tomini. So, as you may recall, Mr Vatistas was authorised by Tomini to defend the arbitration.
Yes, I do recall that. And you put in a defence which objected to the claim.
Disputed jurisdiction. Yes. That was just a reminder. I'm going to make that point.
And he then removed the direct.
In the circumstances explained in the skeleton, I just wanted to ensure that
I don't think.
he's been removed as a director before because he was authorised by the existing law to conduct the defence of the arbitration on Tomini's part. So he wasn't then removed; he'd already been removed and then.
Okay, thank you.
Yes, anything in reply?
My ladies, my lord, yes, and I'm mindful of the time. I will be as economical as I can. 10 points, if I may, in no particular order. Hopefully some order, but not entirely joined together. Question number one, why is Betta constrained to bring a claim in court? The answer will lie not only, my lord, my ladies, in the procedural directions of the tribunal. It will lie in the request that was sought in the original arbitration. As the court will see that document, because the court has asked for the document, that request itself stated that there was disputation about the legal validity of the two putative agreements and sought declarations in that regard. The court will see that the relevant paragraphs are 3 and 48 and 49. The functional reason why this is being done, that is to say, why is it not enough that Betta asks for claim A and Tomini, which doesn't have a defense, why is that not enough in and of itself? The one explanation we have is in the first witness statement of Mr Vatistas, which is supplemental bundle, tab 39, page 263, and I believe we have two references. One is paragraph 112, Roman 2, and the other one is paragraph 62, Roman 3, and I'm happy to leave this for the court's notes. Mr Vatistas is not a lawyer, and I heard what my learned friend said earlier. He's not qualified to speak on legal matters, but his evidence is not contradicted by Mr Salome at this point. There is a valuation proceeding in Romanian court, as I told the court earlier, that requires the court to take a view on the liabilities and assets of the company. And the company has accounting entries which record what they record. A legal ruling is therefore required as to the underlying liability, if any there be. So I believe it's fair to say the company has a position in its books. There is nothing further that it can do. What is now being done is one is interrogating the accounting entries and the liabilities. Are they lawful? Are they grounded in legal documents? That is the position as Mr. Vatistas explains it, and that is the role of the LCIA arbitration, the predecessors of the English court, if I can put it in this way, and the English court thereafter. Now, second point, what is the impact of the outcome of the legal determination? I think it isn't entirely clear, my lord, my ladies, that the value of the shareholding will be wiped out. There is no contestation about that. One point the court may not have picked up already from the documents is that Mr. Diab has exercised the call option on the shares. And that is why my learned friend said earlier that there is a discussion about whether Mr. Diab can acquire the shares and, of course, the underlying assets for a song, is what he said. So that is the missing piece, that there has been an exercise of a call option by Mr. Diab. Now, my learned friend, I'm coming up to my third point, said in that connection, is therefore the outcome of the present proceedings, the court proceedings, directly affecting the interests of Mr. Vatistas in a Rule 19.2, paragraph 2 sense. And we have authority on this proposition. I'm happy to give you the references, my ladies, my lord, and I'm happy to turn to the authority as well. I will be entirely guided by you. The authority is Abraj. The discussion is to be found at paragraph 111 first, where the court discusses whether it is a problem or not. The court concludes that it is not, that a board director who in and of themselves, have no standing and no role, except as part of a collegial body, can be said to be directly affected by a debt claim against the company. The court says not, but it's not a problem for purposes of Rule 19.2, paragraph 2. And if we turn to look at paragraph 115, or if the court turns, well, it wishes, to look at paragraph 115, one will see that the court in Abraj was speaking also of shareholders participating in the court proceedings, because they would be affected too. So the two relevant paragraphs are 111 and 115. And as I say, I'm happy that we'll look them together if the court is interested. It's legal
To that
authority.
passage before.
Excuse me?
You took us to the passage at 115 before.
I did. That is the one that speaks of the original shareholders. And paragraph 111 is where the court addresses the issue of the director and says that isn't a problem. So it seems to us to be unrealistic in real life terms, and also inconsistent with authority to say that Mr. Vatistas will not be directly affected by the outcome. If your shares stand to be valued at nil, you are directly affected by the outcome of this case. Fourth point.
Can you just remind me where the phrase directly affected comes from? Because in Abraj at 111, the judge takes it even further and refers to directly affected in the capacity of a director, which is quite narrow. So I'm just wondering what the origin of the phrase is.
I believe the intellectual paternity of the phrase comes from the decision of this court in Re Pablo Star.
Okay.
I can see my learned friend nodding not so violently but confidently. And the discussion there was, and I'm happy to just give you the lay of the land, my lord, my lady. The document is Legal Authorities Bundle, tab 7, page 139 is where it starts. The relevant discussion can be picked at paragraph 60, which is the paragraph I took the court to earlier, if you will recall. And it continues all the way to paragraph 69. And the court speaks of some direct effect in that case because the Court of Appeal goes on to consider in what circumstances some third party can intervene in chancery proceedings in the context of shareholders asking for the registration or re-registration of their company. So how direct must the intervener's interest be in order,
It's paragraph 62.
in order for them to be admitted? But then the court goes through the cases. 59 as well, I'm being told by my learned friend. And we see the discussion of the cases and the different types of connections. So it comes from that context, from Pablo Starr.
Thank you.
Thank you, my ladies, my lord. I was coming to my fourth point. I understood my learned friend for Tomini to say that there is no evidence of practical control by Mr Diab on the board of Tomini. I understood him to say that. If I have that wrong, I will apologize. What we have in the record, I'm very happy that we opened the bundle together and I can walk you through the materials and leave them for the attention of the court, is the story. Can I ask that we pick up the supplemental bundle? I need to find my copy as well. So,
Well, I don't want to take you out of your course, but a document that struck me when we were taken to Procedural Order 7,
yes,
appears at 322, tab 47, where the arbitral tribunals say there's a real risk that Mr Diab is disregarding the separate personalities of Betta and Abbottswood and using these entities interchangeably to control the outcome of the arbitration by taking steps to procure that the very serious issues of fraud and illegality will not be duly aired.
yes. Yes, my lady, and I had the intention of being more economical, even than that. This is an important document. It's reasoning for procedural directions by the tribunal. Can I ask that we start at tab 24? I will go to these documents as well. I had the intention of doing so. Tab 24 is a communication by the board of Tomini dated the 27th of June 2022, and if you turn to page 177, you will see that it is signed by a three-person board, including Mr. Salome. If we turn over to page 176, on the right-hand side, we have the English text. If we go to the fourth cell from the top, this is the board writing to Mr. Vatistas, who has been given the mandate at that stage entirely unilaterally to have carriage of the arbitration, the board says, as regards the arbitration, please note that the proceedings are in an early stage without a statement of claim and proper evidence having been submitted yet. According to the applicable rules of the LCIA, by not having, yet submitted a response to the request for arbitration, the company is not precluded in any way from denying any claim or from advancing any defense, counterclaim or cross-claim in the arbitration. So that is in June of 2022. If we turn to the next document over, which is tab 25, this is a shareholders resolution authorizing Mr Vatistas to have carriage of the arbitration. This is 1 month later at the request of Mr Vatistas. And you will see, if we turn to page 181, forgive me, 180, on the right-hand side at the bottom, one sees that the board is informed by Mr Vatistas upon the following, and then we have a number of paragraphs. The third paragraph, which is at the bottom of the page on the right-hand side, says this: what is more, on Betta's own pleaded case, the arbitration will raise serious questions of fundamental illegality and invalidity. These have a complex and extensive factual background which will require thorough investigations as well as sophisticated legal developments, and so on and so forth. And the shareholders approve Abbottswood not voting on this, approve that Mr Vatistas have carriage of the case. The two key documents, this was background, the two key documents I wanted to show the court, if I may, are the next two. Tab 26, please, my lady, my lord, page 183. This is an email from Mr Diab, Mr Diab. You will see at the bottom of the page it is signed Betta Oceanway. So this is Betta, the claimant. He's writing to the board of Tomini, Mr Aid, Mr Salome, and Mr de Vlasian. And I'm happy to leave this to the court's own time to read. He is telling the board of the other side that they should agree to discontinuance of the proceedings without prejudice. And just 10 minutes later, this is over the next tab 27, page 184, he writes to them again. This time it is even clearer. If you will see at the bottom of the page, it says, on behalf of Betta Oceanway, the claimant. And you will see the message under the reference line is, I write to you in your capacity as directors of SC Tomini Trading and in relation to the arbitration in London. And then he asks them to agree to discontinuance within 12 hours or so. So, my ladies, my lord, these are the materials that the tribunal had when it issued. Forgive me, perhaps we can see the end of the story. It's the next document over, tab 28, page 185. So the Tomini director signed this document.
Tab 26.
Tab 28. Page 185. So the Tomini directors write, Mr Diab, dear sirs, regarding LCIA arbitration number 225492, the position of Tomini directors is communicated as follows. The court can see what it says. Number one, we agree to discontinuance. So the arbitral tribunal had seen all of that and then issued its procedural orders with reasons, which are at tabs 30, 31, 34, and 35 of the supplemental bundle. And they said what they said, but can I ask that we turn to tab 36 of the supplemental bundle? This is the judgment of Mr. Justice Dias. Forgive me,
Mrs.
I don't know what I said. Mrs. is what I had
Head
in mind.
Mr. But
Forgive
sure
me,
she'd-
Mrs. Justice Dias is what I meant. Can I ask that we turn to paragraphs 85 to 86? This will be at page 220 of the bundle. At paragraph 85, the court says it is fair to say the tribunal clearly formed a less than favorable impression of Betta and Mr. Diab, not for me to express an opinion one way or the other. And at paragraph 86, the learned judge says, I therefore proceed on the basis that the tribunal genuinely and in good faith, identified a potential for abuse. And that was the procedural abuse, my lady, that also the tribunal had identified earlier. So I say this with the greatest respect. It seems to me to be bold for my learned friend to be saying that there is no evidence of direct intervention by Mr. Diab in the affairs of Tomini. There was evidence, and it was before the arbitrators and then considered by the English court as well. I come now to my fifth point, if I may. Now,
And this was an application to set aside the procedural order issued by the arbitral tribunal.
correct, my lady. It was, in fact, slightly more complex than that. There were two procedural orders by the tribunal. In fact, there were three, but two are the main ones. The first one, the tribunal thought would resolve the issue by ensuring that all three parties would end up before the English court, which is what Betta assured the tribunal it would do. Then there were some developments that the tribunal hadn't anticipated. The process was not moving forward quickly, and no one had anticipated that Tomini might block the participation of Mr. Vatistas in the English court. So a further procedural order was issued. That was then being challenged as an award, that further development. And Mrs. Justice Dias, entirely and impeachably one would say, said, yes, these are binding orders for the parties, but they're not awards because they do not deal with the substantive dispute of the
Resolve
parties.
the issue.
Indeed. And in that context, so the court has it. It is often said that Tomini, when Mr. Vatistas was handling this dispute, contested the jurisdiction of the tribunal. That, I'm afraid, is not correct entirely. There was a full defense on fraud and illegality, and at the very end, it was said, for completeness and honesty to the tribunal, if these putative instruments are illegal ab initio, then everything in them is illegal ab initio, and there is no separability presumption that would apply in these circumstances. Everything would fall to the ground, including the arbitration clause. There was no objection to the tribunal. In fact, every intention of submitting to the tribunal the issues of fraud and illegality, without any question. This is simply so the court has the full position. Now, my fifth point.
Presumably, your client wasn't part of perhaps even didn't have notice of the application to Mrs Justice Dias?
That is correct. That is entirely correct. We found out after the event, and we obtained our own copies of the materials. They were never shared with us.
Tomini, I suppose, must have been served or notified, but didn't bother to turn up.
I understand from my learned friends that the answer is yes. My friend Mr. Reed appeared for Betta.
And
And Mr Samuels,
And
but
Mr. Sam.
no appearance for anybody else.
Miss Thompson was there for me and did not oppose, but brought the
Didn't make it onto the
no, apparently
front
brought the legal point that was decisive to the attention of the
Thank you.
Fifth point, the realistic position on how one might establish the risk of abuse through the process of the English court is simply this. We, the Vatistas side, accept entirely we have to establish a proper, forgive me, arguable case, a properly arguable case, that these two putative debt instruments are based on known falsehoods and therefore are sham. We cannot possibly establish, I just wish for the court to be clear on this, collusion on affirmative evidence, not even on tentative evidence, simply because we do not know how the internal affairs of the Tomini directors and any interactions with Mr Diab or other colleagues of his work. We have no insight as to these matters. The Tomini directors, through my learned friend, their counsel, say they have taken advice on the issue of the claim, and they have taken a position based on that advice. Mr. Salame says, I waive no privilege in respect of that advice. So there is nothing we can test and no evidence we can now mine for to show collusion. What we can show, and at least on the basis of the properly arguable case standard, is that which the court is asked to say is legally valid and enforceable is predicated on a known falsehood and therefore is a sham. But that is enough, is the point I wish to make. And one authority on which all the parties agree, and therefore it hasn't even made it to the authorities manual, the decision of the Supreme Court in Tahar, 2020 Supreme Court Reports, paragraph 52. This was a case where a judgment was reopened, even though the judgment was reopened. The question was whether the court had been misled using a fraudulent document in circumstances in which the defendant might have been negligent in not uncovering the fraud and therefore to an extent responsible for what had happened. And the court says, citing to Canadian and other authority, at this paragraph 52, to allow judgments which are infected by fraud, even if one side has been passive in the fraud, would be not only against the law, it would be against the rule of law. It's fundamental. We have to give an opportunity for the judgment to be reopened and examine whether it has been infected by fraud. So it's quite an objective matter, and I need not establish or plead collusion, also for the reason that I am unable to. These are matters which are opaque to Mr. Vatistas. Sixth point, it was said that there is a three-stage test under Rule 19.2, paragraph 2. First, the gateway. I think we all agree on the gateway. Then we have the test of desirability. Part of the desirability test, I think now everyone agrees, is hard-edged legal tests, as I called them earlier. and that is in particular for the test of a properly arguable case. My learned friend for Tomini suggested to the court that there is a third stage, which is you exercise an overall discretion thereafter. I respectfully submit that is wrong. It doesn't make a lot of sense on the text. There is a multifactorial evaluation, but there is no discretion on top of that. It wouldn't make sense for there to be, and the text doesn't suggest otherwise. The one judgment we have in the record, which is very systematic about the application of Rule 19.2, paragraph 2, is Molavi's supplemental bundle tab 1, and the relevant passages are at paragraphs 14 to 50. I'm happy to leave this entirely to your notes. The court, this is Mr. Kimbo KC sitting as deputy, says that once you're out of the gateway, then you stand back to evaluate a number of factors as part of the desirability test. He does not say you do that and then you stand even further back and you exercise overall discretion. So it is a two-stage inquiry. Seventh point, I think there was a suggestion that the Vatistas proposed joinder is done on a wait and see or why not basis, terms that were used by the court in the Brothers case. That's quite unrealistic, isn't it? The defense by Mr. Vatistas has been crystal clear. It's been articulated in LCIA proceedings 2 years ago. Everybody in this room knows it in great detail. Strikeout, which is what we're suggesting should be, what our learned friends were suggesting should be requested, cannot be had. At present, we are constrained to take the witness evidence of Mr. Salome as true. We will test it in due course, but for now we have to take it as true. So there can be no strikeout for now. We will join in the proceedings and then we will articulate a position, not in the name of the company, of course, but in the name of the joinder. Coming to my, I believe, eighth point, my learned friend also referred to evidential materials. And I will not have time to take you to more materials. And as I suggested earlier, I'm not sure it would be fruitful. But there is one case I wish to take the court to, if I may. That is one of the Abramovich cases, Legal Authorities Bundle, tab 6. Please. At page 120 of the bundle, paragraph 20, this was a case where fraud was being alleged and a strikeout application had been lodged. The court says this, starting on the second line: the claimant does not have to plead primary facts which are only consistent with dishonesty. The correct test is whether or not, on the basis of the primary facts pleaded, an inference of dishonesty is more likely than one of innocence or negligence. As Lord Willett put it, there must be some fact which tilts the balance and justifies an inference of dishonesty. It is in the nature of the case that the test will have to be on that basis at most. But I will say that my learned friend referred to a number of documents in 2015 and 2016. I referred the court to materials in 2009 at the genesis of events, which do not involve evidence from Mr. Vatistas. I showed the court objective documents involving 3 parties from 2009, and these, at the very least, are consistent or do not disprove, I'm putting this at a minimum, Mr. Vatistas' fundamental point, which is an amount of $40 million was never, ever owed to Mr. Diab via any one of its companies. So my friends, a little bit like the Diab group, are taking the court to a number of documents which are internal documents of assignments and so on from various parties to other parties on notices of assignment and so on. And you have a number of those in the record. But the root of the events involves three parties, their objective papers, and I referred the court to those. My friend did not pick up mantle of that debate, and I will leave it there. Two more points, if I may. A reference was made, I think this is my 10th point, reference was made to the judgment in Wise Payments. This is Legal Authorities Bundle, tab 15, page 73. Add paragraph 73 as well. And the page number reference is 318, my ladies, my lord. So at paragraph 73, the court says this, 5 lines from the top, a weak case which will require significant work to make good and which will entail additional complexity for limited gain is less likely, and so on. Now, this was said in the context where one party was trying to implead other potential tortfeasors. I will leave this reference for the court, and the court can look up the point for themselves. Here, the circumstances are very different. The court was making an observation which is quite case specific. And if the key point is whether there would be limited gain or not, well, the court, I suspect, knows the answer to that. If Mr. Vatistas' case has a whiff of credibility, then the court ought to admit it. My lord, that's my last point. My lord, Lord Justice Mayles, asked the question whether Mr. Vatistas would be amenable to some kind of comfort to the other participants, the claimant and the respondent. And we've considered that carefully, and I would say 3 things. One is that there has been no application for any form of security in any of the proceedings. Mr. Vatistas has complied with the orders, the cost orders of the court below, seeking leave to appeal, both from the court below and from this court. So he's playing this fairly, and he's putting up resources. The second observation is that I can entirely see the logic of having some form of fortification or a bona fide indication of seriousness on Mr. Vatistas' part, who is after all an individual. That is entirely understood. And out of the jurisdiction. And out of the jurisdiction. As is everyone else in these proceedings, well, that's my lady. The one hesitation we have, and I will be very candid with the court, is this. Every time Mr. Vatistas has a participation on the merits of this debate, some circumstances found to stifle him. In the underlying arbitration, first there was no budget for him. There was a paltry budget of 30,000 to get counsel. He paid out of his own pocket for the legal team. Then when he put up a defense, the case was discontinued and his authority was withdrawn. Then when the case was remitted here, Betta said they're willing to participate with Mr. Vatistas involved, but then Tomini said, we are not content. So every time there is a difficulty, we are concerned that if we give an open-ended undertaking, that we would be happy to consider some conditional order, for example. This might be used to stifle us again and ask for, say, an undertaking of several million, which would be very difficult. All this to say that if the amount is to show a token of seriousness and commitment of the order of £300,000, £400,000, something of that nature, that would be entirely unopposable because it would not stifle the effort. And I am sure my learned friends would accept that in that hypothesis, of course, we would have a cost order in our favor. That cost order would be set off against the fortification. So we understand entirely where the court comes from. We have the overarching concern of access to justice.
Understood, thank you.
My ladies, my lord, that completes our submissions.
Yes.
My ladies, my lord, I'm acutely aware of my lady Justice King's appointment, which is one which rejoinder on the law with a three-stage test for joinder. So step one is real prospect, step two is
Yeah, well, we know what you said the three were.
design
Can you
work,
take
step
us
three,
to?
Pablo Star, page 150, paragraph 47. I'll just read it to you. 19.2 confers a discretion to join on the court to join a party if the conditions in rule 19.2.2a or b are satisfied, and that's consistent with the wording of 19.2 itself, which is the court may if a or b. So the discretion is residual and comes after the evaluating judgment as to desirability.
Thank you.
My ladies, my lord, a point of information, we have copies of the request for arbitration and the statement of claim. They went together for the court.
You've got copies for the other side, have you as well? Great, excellent, thank you very much indeed. Well, can I thank you all very much indeed. I'm very conscious that you've had to get through an awful lot of material in a relatively short period of time, although we have in fact managed to fit in a full court day. Can I thank each of you for your helpful submissions? Special cheer for Ms Thompson, to be the only junior making substantive submissions, so thank you, Ms Thompson. You won't be surprised to hear that we're going to reserve our judgments. They will be sent through in draft in the normal way. May I please, in a case like this, remind everyone particularly of the embargo at the top and the importance that it is treated confidentially, and the embargo is observed until such time as the judgment is finalised and handed down. We'd hope that we'd be able to deal with any other matters on paper and that you would be able to agree an order. If not, we will have to deal with any other applications in writing. So thank you all very much, and those sitting behind the front row. So thank you.